Welcome to 13. Today's a little different. What we're going to do is I'm going to go through this. And as I go through this, please leave your comments below and questions. I really want to see all of this because we're going to be talking about, and I've written out some specific things here from many different articles. We're going to be talking about ballot question 3 in Massachusetts, as well as the recently passed Uber Lyft controversial $32.50 per active hour, not per hour, per active hour. It's been a whole deceiving process. It's been going on for years, but I want to walk you guys through this. So here are my notes that walk us through first. So for those that remember, so question 3 on the ballot that just happened, voting just happened. This is in Massachusetts. Voters to decide if ride-hailing drivers can form unions to collectively bargain with apps like Uber, Lyft for wages, benefits, work condition if the measure is approved. Massachusetts would be the first U.S. state to allow ride-hailing drivers to unionize. Understand that before we move on, the deal that was made between Maura Healey, who is now the governor of Massachusetts, and used to be the Attorney General, and now Attorney General Andrea Campbell, they made a deal that they've been working on for 4 years with Uber and Lyft, and it finally came down where it's kind of like a Prop 22, okay? It's saying that that Uber and Lyft will pay $32.50 per active hour to an Uber or Lyft driver doing rideshare, per active hour. Now remember, in New York City, before I go on any farther, this has led to 75% of the rideshare drivers in the New York City area alone not being able to get on the platform at all. I'm not talking about minimal time or I'm only getting these bad shifts. They can't get on at all. And in fact, there's a lot of stories running on that we'll be discussing as well later this week, because they're trying to make that look very good. But really, you lost 3/4 of your drivers that can no longer do this. And here's why, and I think you guys will pick up on this. But if not, again, please leave all of your questions, comments, concerns below, because that is what gets more eyes on these videos. So we've had a lot of 13s in a row that have been very important. So in 2020, like I said, Maura Healey was then the Attorney General. She was going after the transportation companies. And finally now, this year, they made an agreement in June with Uber and Lyft that went into effect in August that established a $32.50 minimum wage for active time, earned sick pay, and a couple other benefits. However, the settlement did not include or does not change their employment classification. Now, understand this. Uber and Lyft agreed to this deal this deal after fighting it for years. So after saying no, even though it's much like Prop 22, what they did was they said, okay, we accept this, but here's our only thing that we ask for. Because you're going to hear a little like conflicting evidence here, or not evidence, but conflicting messaging. So they agreed to this. They said, that's fine. It sounds like a lot of Prop 22 language. We'll deal with that. Most drivers in the Boston market make over $32.50 per active hour. Know that. But what they did was they said, we need these 7 things to happen. Uber and Lyft had been fighting it. They said, okay, we'll make that happen. They said, however, we need one thing from you. Just one. What is it? Well, drivers can't unionize since we're giving them this hybrid status that we've done in other states, which is the same thing they do in every other state. And they said, okay, no problem. Well, guess that now, almost within a week of that happening, Andrea Campbell and Maura Healey came back and put on the ballot question 3. If the state's voters approve the measure of question 3, ride-hailing drivers in Massachusetts will obtain their right to unionize. The law would also provide a framework for how the union would form. Understand this. They asked for 7 things. Uber and Lyft said, okay, we can do that if you do this one thing. The one thing that they asked for is now been, they decided, screw it, just put it on. They already agreed to it. So they put this on the ballot, and the way it was worded, if you haven't seen it on the Be My Own Boss podcast, you can find it on YouTube, Be My Own Boss podcast. Mike Harubi spent 1 hour and 10 minutes reading ballot 3 question. That's how long it took. It was longer than the Constitution of the United States. One ballot question. That tells you right there how sneaky this is, but hold on. So here's how it would work. If passed, drivers could participate in the union process as long as they've completed at least 100 trips per quarter. So per 3 months, have you done 100 trips? But that, it makes it sound like you're going to get into all this. You're not. That allows you to be part of the next stage. The next stage is the proposed law would allow the state's Employment Relations Board to review if a union or driver organization is referred to in its ballot language has 5% of signed support from active drivers. Now, active meaning not active on the platform, active meaning what I just said above, 100 trips per quarter. So if you've done that, you would be active. If they can get 5% of that, then they can form the union. If the board finds the votes are in, that would allow the driver organization to obtain a list of other drivers for the app companies. Understand what that means. If 5% of the people doing 100 trips per quarter say, yes, we want a union, you can find that 5% at any given big airport. Like, so Boston Airport, you're going to get your 5% right there. Because there's a lot of people who don't understand this language. They're going to do that. At that point, and this is a big, scary point, the unions all have your information. All of you that work on the platform. It kind of takes away a bargaining power, and it also presents a threat. If 25% of the eligible drivers then give their signatures to authorize a specific union, the union then can be designated as the exclusive bargaining representative for all drivers. So if you get the 5% to say, yes, we want a union, then the union obtains all of the names on the in the database. They have all of your information. They will approach you if they get 25% of the people doing more than 100 rides per quarter. Now they can approach all of you, and if they get the 25%, all of you are in the union, whether you like it or not. And you're not even employees. So this isn't even a thing. It shouldn't even be legal. The ballot proposal calls for the state Employment Relations Board to determine when a driver organization has reached the required percentage of all this, making sure that they've hit these numbers correctly. Okay, so the measure does not include other app-based gigs like Instacart or delivery-based apps like Amazon or DoorDash, those kind of things. But hold on, because that comes back into play. So Boston University law professor said the proposal asks voters to think about labor relations in Massachusetts in a slightly different way. The traditional union, an organization, negotiates work conditions and benefits like health insurance and retirement contributions on behalf of employee with their employer. O'Brien, the law professor, said that the proposal to have an arrangement where you could, as an independent contractor, be in a union blurs the distinction between contractors and employees. 100% correct. While the ballot question provides a framework for how a union would form and what role state labor entities would play, O'Brien pointed out that it does not detail other union practices and procedures. So basically, who supports this? Who supports this? The SEIU, the International Association of Machinists in Massachusetts, Local 32BJ, all of the things that you'd expect unions. Who opposes question 3? So here's where it gets a little dicey. Opponents worry there would be unintended consequences to allowing ride-hailing drivers to unionize via ballot measure. A spokesman for the nonprofit Massachusetts Fiscal Alliance said question 3 prevents several points of concerns. For one, he said unionization could lower wages for drivers. We've seen that happen in every state they've tried this in. Prop 22, pay up in Seattle. We're about to see Minnesota play out poorly. New York City lost 75% of its drivers. And he said his group argues that could mean higher trip rates cost to passengers who may be charged more to make up the difference. 100% already happening. So, okay. So the Alliance also questions the necessity of drivers forming a union. He ticked off a list of drivers' protections and benefits the app-based workers now possess in the wake of the Attorney General's settlement. This is a quote from him. They have forms of paid sick leave. They have forms of paid family and medical leave. They have health care stipends. They have on-the-job injury insurance, he said. They have anti-discrimination protections. They have domestic violence leave, anti-relation protections. So he further said he wishes drivers had been given more of a chance to let the dust settle and experience what has been enacted as law, this 3250 and all of these benefits. But they wanted question 3 on there. So there is a possibility that if passed, people would come forward and challenge it in federal court. It would take years to get litigated because he also believes question 3 breaks federal and state law because it would give a subset of independent contractors the ability to unionize that others would not have under the NLRA, the National Labor Relations Act. That is a big problem, you guys. So what did they do? They passed this, and I just want to tell you guys what happened. We voted this last week. We all know this. But here is the results for question 3. And it was a lot closer. We thought I knew the results wouldn't be good, but it was a lot closer than I thought. So a lot of people were in tune with this was not a good idea. So question 3 did pass. They can unionize now. However, it's going to be a nightmare, and potentially Uber and Lyft leave the state. Do you think they will? This is different than all the other states. Do you think they will if they're pushed to this? Because question 3, rideshare unions. Should rideshare drivers have the right to form unions? The votes that came in Tuesday, yes, 53.8%. No, 46.2%. I'm very proud of that no. Let's stay tuned with this. That's 13 minutes of gig news in just under 13 minutes. Peace, y'all.